Michael Clark. We're on the record in cause number 323-744. The case is styled the state of Texas versus Michael Clark. That's your full name?
Yes, sir.
How you doing, Mr. Clark? You doing all right? Mr. Clark, you're here represented by your attorney, Mr. James Paget. Mr. Paget, how are you doing?
I'm doing well, Your Honor. Thank you.
That's good. Mr. Paget, Mr. Clark's case is on the court's trial docket. What's your announcement on this case?
We're going to stay on the trial docket, Your Honor. We're ready to go.
Okay, so I think this was not one of our trial weeks, even though we have a jury coming. We got a jury coming. We got a couple of cases specially set for tomorrow.
Okay, I understand.
So could you give us a trial date? December 6th. Okay, the case is reset to December 6th, 2021. Now, Mr. Clark, I have before me some, hand this to your attorney so he can hand it to you, some standard bond conditions. Mr. Patrick, could you
Yes,
hand
Your
that to Mr. Clark?
He's going to read this to you. You just want to just hang on to it and follow along with you.
Okay, now, Mr. Clark, what you have before you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay, I'll go over these bond conditions with you. It says, following the arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. That's pursuant to Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And I think the alleged victim in this case is Denise Clark. Do you understand that condition?
Yes.
And condition number 4 only applies in DWI cases, so it does not apply to you because your case is not a DWI case. Now, Mr. Clark, if you fail to adhere to any one of these conditions, your bond can be revoked, warrant will be issued for your arrest, and you can be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes.
Now, Mr. Clark, your case has been reset for trial on December 6th of 2021. Your attorney will sign for your reset. Once you get your reset from your attorney, you're free to go, and you have a blessed day.
All right. Thank you.
Fernando Cabrera.
Yes, sir.
Okay, we're on the record in cause numbers 324, 368, and cause number 329074. Both cases are styled State of Texas versus Fernando Cabrera. Is that your full name?
Yes, sir.
How you doing, Mr. Cabrera?
Doing good. How about you?
I'm doing fine. Mr. Cabrera, you're here represented by your attorney, Mr. James Paget. Mr. Paget, I don't see your name on the second case. I'm looking at the docket.
I haven't been hired on the second case, Your Honor.
Oh, okay.
I'm on
You-
324, 368, Your Honor.
Okay.
I just
Now,
thought you were putting the conditions on both, so I was just gonna let you.
you're right. What is his bond set at on these cases? His bonds. What is his bond? I see you got a PR bond on one. That's the new one. Cabrera. On a deadly conduct case, is that a PR bond? Yeah.
There's a cash bond on the daily conduct,
What's the cash bond on that one? What's the amount?
7,500.
Okay. Okay. Okay.
And then the cash bond on them is,
Okay.
yeah, yes, cash bond on both the cases.
Okay. I thought it was okay.
Huh?
Okay, so you got cash bonds on both. Okay.
Yeah. it's
That's
cash
my
bond,
understanding, Your Honor.
Pre-child monitoring, it's a cash bond. Yeah.
Let's see. Hold on a minute. Ah. Okay. Okay. Okay, okay, we're on the record in cause numbers 324-368 and cause number 329074. Both cases are style the state of Texas versus Fernando Cabrera. Now, Mr. Cabrera, I have, uh, let me hand this to you. I should have made it. Hold on a minute. I wrote that on there. I need to write it on here too. Okay, let me get this to him. Okay, now, Mr. Cabrera, what you have before you is a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document? Okay, now, Mr. Cabrera, I will go over this document with you. And it states, following arrest and or accusation in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Yes, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition? Yes, sir. And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And the alleged victim in the family assault case is Kathleen Gonzalez. And the alleged victim in the deadly conduct case is Melissa Martinez. Do you understand that condition? Do you understand that condition?
What if I have,
No. Oh, okay, I'm not representing him on that case. I've already advised him not to do what he's going to do. However, he's representing himself on that, so.
I got kids with both of them. So.
Okay, the condition is you shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that?
Well, in that case, how am I supposed to look at my kids?
I didn't understand what he said.
How am I
Your
supposed
Honor, I can't interpret for him.
Well, these
I don't
are the
understand.
these are the conditions of your bond. Okay, you violate the conditions of your bond can be revoked, and you can be placed in jail. Do you understand that?
Yeah.
All right. Now, Condition number 4 doesn't apply because it's a DWI case. However, I did put in a 5th condition, okay? And you have this new case, the second case, which is a deadly conduct case. You're gonna participate, and these cases did not occur on the same day, they're different dates and different times. You're gonna participate in the global positioning monitoring system, which is a GPS, immediately. So you're gonna have to get a GPS monitor, okay? Do you understand that? And then you need to immediately get it, and you need to give a verification to the court that you have it. Okay? So I'm gonna give you, well, you need to get it today. Okay. Now, Mr. Paget,
Yes, Your Honor.
pursuant to the case that's the one case that you have, actually, that's on the trial docket that you represent him on, you're gonna have the same announcement
Yes, Your
that you had on
Honor.
the previous case?
I have advised my client that he should contact me regarding that other situation, but obviously I can't, of course.
I understand that. So we're gonna reset it to December 6th of 2021. And Mr. Cabrera, this case, the first case, which is cause number 324368, the case that your attorney is representing you on, that case is reset for trial on December 6th of 2021. Do you understand that? Now, you're gonna get your reset from your attorney on that case. Now, the second case, you haven't hired Mr. Paget on this case, but we're gonna carry this case on the same date unless you wanna do something different with that. And what I mean by that is, let me do this here before we go any further. Now, Mr. Cabrera, in reference to cause number 329074, as a defendant in the criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that option? Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option? Number 3, you may represent yourself. Do you understand that option? If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, the document, there's a document there that we'll have the bailiff to give to you. Mr. Monty, could you hand him the judge's explanation that I just went over with him? At the bottom of that document, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If your choice is, I've hired an attorney whose name is, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed court-appointed counsel, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you finish making your choice, one of the 5 choices, you will sign on the line that says defendant and you'll place today's date, June 21st of 2021. Do you understand? Okay, you may sign.
Can I give you this copy?
give me a copy.
Yeah, for case number 329074.
I can't take any, that's export take communications. I can't take any, paperwork from you or anything. Okay?
All this copy says is that,
Well, you don't read it. I don't need to, know what it says, okay? If you're represented by your attorney, you can hand your, whatever you need to give to your attorney. Okay. Okay, so you want to hire, okay. So your case is gonna be reset, to give you time to hire. What we need to do is probably give it, how much time do you need to hire your attorney? Do you need 30 days, 60 days?
We're not putting it on the same day.
I need some time, I'll pay all my money with the bond.
No, I'm just asking you, how much time do you need to hire your attorney? Normally, we reset it for either 30 days or 60 days. You can do it in 30 days?
I'm trying to keep both cases, same time.
I know, but you have a lawyer on one case and you don't have yeah, we're not gonna reset it to December to give you time to hire an attorney on the next case. 30 days will be fine? Okay. Let's reset him for 30 days. Well, let's do this. Give him 45 days. Give him a little bit more time.
Okay.
Reset him for 45 days. That case is gonna be reset for 45 days. Give you time to hire your attorney. You hire your attorney knows what to do to try to keep these cases together, okay? All right, stand over there. Now you need to provide us proof of that GPS. You should be able to get it today.
Where do you get the GPS monitoring system?
Hmm?
Where do you get that at?
Do we have any information on where you can get that, the GPS? Just get your reset, have a seat, and we're gonna see if we could find out where you can get that information from. If it's not, you can't Google it and find out, okay? Just get your reset and just have a seat. You have a key ready?
Go ahead, sign it. You want to see it, but I will.
Calvin Lamore.
Facility, we can get the GPS. You might know.
Oh, you misspelled?
You contact the court. You're gonna have to send a copy.
Lamar, 324-688. Hold on, come on now. Let me get. Who's per?
Creekmore.
It's Creekmore, get, Creekmore in it. What's that, case?
Oh,
Oh, what's,
328-796.
what page is that?
Ninth page.
Okay. Okay, Mr. Creekmore, you come forward. We're on a record in cause number 328-796, case of style of state of Texas versus Levi Elwood Creekmore. Is that your full name?
Yes, sir.
How you doing, Mr. Creekmore?
Doing fine,
I'm doing fine. Check and see if you got some bond conditions. Mr. Creekmore, you're here represented by your attorney, Mr. Alwyn Samuel. Mr. Creekmore, how you doing? And Mr. Samuel, how are you doing?
I'm great, sir. How are
Yes,
you?
I'm doing fine. Let me see, 328-796. Yeah, that's the cause number.
Yes, sir, he does.
Okay, okay. Okay, now, Mr. Samuel, you have an announcement in Mr. Creekmore's
Yes,
case?
Your Honor. We received discovery. We had the DVD. We got the DVD on last week. I've not had an opportunity to go over it with Mr. Creekmore. We don't have an offer in this case. So I'd like to have at least another setting to review all information with Mr. Creekmore and to get something from the state as far as a possible resolution to this case.
Could you give us a reset date? Standard reset 30 days, announcement
August
document.
2nd.
Okay, this case is gonna be reset to August 2nd, 2021.
That's great.
Mr. Creekmore, you're gonna get your reset from your attorney. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, you too, sir.
Okay, and just
Thank you,
continue to adhere to those bond conditions.
Yes, sir.
Okay,
Thank you, sir.
okay, you're welcome. I think we got more. Calvin Lee Lamar. Who's his attorney? When the pleas are ready on Charles Bell and Dominique Grayson, we'll call those cases.
Your Honor,
Yeah,
I texted Mr. Smith just a moment ago regarding the plea on Dominique Grayson. So as soon as we can get that straightened out, we should be able to move forward with that paperwork.
okay, yeah, he's not in here at the moment.
Okay.
We're on the record in cause number 321-234. The case is style of state of Texas versus Jimmy Lee Doss Jr. Is that your full name?
Yes, sir.
How you doing, Mr.
Doing
Doss?
good. How about yourself?
I'm doing fine. Thanks for asking, Mr. Doss. You're here represented by your attorney, Mr. John West. Mr. West, how are you doing?
Doing good, Your Honor.
Okay, Mr. West, you have an announcement you'd like to make, Mr. Doss?
Your Honor, I need to talk to Mr. Doss outside. It's
Okay.
It'll be trial or plea, and I'll let the court know.
Okay.
For one of the two.
Okay. Mr. Doss, just have a seat. Also call the next case for Mr. Okay, Cherish Lawrence, that's her.
That's my Your Honor, on this one, she has a warrant out for
Okay,
a warrant for arrest that is out in custody right now. I sent a message to Miss Maxey about that. We're trying to work on seeing what we can do, whether
Okay.
we complete it all out or not, but.
okay,
I'm
we'll
working
hold
that
on.
right now.
Okay, we'll hold on.
Yeah, hold out.
Okay.
I'm trying.
Is Kaden Hayes here?
She didn't answer this time, Ron. Sure.
Okay. Oh, good morning. How you doing? Okay, Mr. You approaching on Mr. Doss?
Yes, give you a quick update. I refresh my memory and get exactly where it is. This is an individual who is supposed to pay some restitution. The case is going to be dismissed for restitution. He doesn't have it quite all together yet. It's $682. So we would just see if we can get another,
Mr. Doss?
a little more time to get.
Yeah, okay.
And it sounded familiar, but it didn't quite spark my memory until I looked at the notes.
Now, Mr. Doss,
sir.
now state, we have an offer to Mr. Doss to pay some restitution in the case.
That's correct, Your Honor.
Okay, now, Mr. Doss, how much time do you need to get the restitution?
At least 30 more days.
30?
Yes.
Okay, we're gonna reset him for 30 days to get the restitution. You can get your reset. Once you get your reset, you'll be free to go.
Yes, sir.
Okay, and you have a blessed day.
You too.
Your Honor, I still have Ms. Flores I'm working on, but I do have to step down to the
That's fine.
Judge West's court. I'll be back.
That's fine. Is Kaden Hayes here?
Yeah, Madam Pro Tem, that judge,
Go ahead and sign.
and I told him the plan. He thought I told him he could leave, and he left, and he went to work, and he's at work in Port Arthur. I just called him.
Okay, you can report in 3 ways, either Zoom, telephone, or in person. So you need to
Okay.
see what you can do to get in the reporter. I mean, to make an appearance in one of those 3 ways.
Okay, thank you.
All right. Okay. Lamar. Is Lamar ready?
Lamar.
That was the first one you had. Okay. Calvin Lee Lamar. Mr. Lamar, would you please raise your right hand? Mr. Lamar, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Lamar?
Good. How about you?
I'm doing fine, thanks for asking. Mr. Lamar, you're here represented by your attorney, Mr. Bruce Smith. Mr. Smith, how are you doing?
Fine, sir, how are you?
I'm doing fine. Mr. Lamar, the information in this case alleges that on or about May 26th of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault family violence. Mr. Lamar, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Lamar, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Lamar, I have before me a document that is titled the misdemeanor plea admonishment. It is also labeled as State's Exhibit Number 1. Mr. Lamar, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Lamar, are these your initials on the line that is what a box is checked, nola contingere, which means no contest?
Yes, sir.
On page 3 of this same document, Mr. Lamar, is this your signature above the line that says defendant?
Yes, sir.
Mr. Lamar, there's another document here. This document is titled the trial court certification of the defendant's right of appeal. Do you understand?
Yes, sir.
Do you recognize this document? Now, Mr. Lamar, is that your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
Mr. Lamar, I also have a document that is titled the discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on this document, the discovery certification above the line that says defendant?
Yes, sir.
Now, Mr. Lamar, prior to signing and initiating all of these documents, did your attorney, Mr. Smith, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. State, I have before me State's Exhibit Number 1.
Hi, how you doing?
Well, sir, would you please put your mic on mute? We'll get back when we call your case. Okay. Let's see. State, I have before me State's Exhibit Number 1, which is the misdemeanor plea admonishment. You like to offer that?
Yes, Your Honor. I'd also like to offer the probable cause exhibit as State's Exhibit Number 2.
No objection.
Okay, no objections to State's Exhibit Number 1 and Number 2. Mr. Smith, you've advised that counsel, Mr. Lamar, is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
Mr. Lamar, your attorney, Mr. Smith, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Okay, Mr. Lamar, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. And I will also find that your pleas and waivers was freely and voluntarily given. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
It's for 180 days, probated over 18 months, an $800 fine, 80 hours community service, anger management, and no contact with Melissa Elliott.
Okay. Mr. Lamar, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in jail because you'll be on probation for 18 months. During the 18-month probationary period, you'll be required to pay a fine of $800 plus court costs. The court costs in this case is $352. So the total fine and court cost is $1,152. You'll also be required to pay a probation fee of $60 each month and a urinalysis fee of $15 each month. You'll also be required to reimburse the county the court-appointed attorney's fees of $250. Now, Mr. Lamar, your total monthly installments, that is how much you would have to pay each month for this case, is $160. Would you be able to pay the $160?
Yes, sir, I can make that.
Okay. And Mr. Lamar, you will also be required to perform 80 hours of community service. You would have to pay $100 to the Family Violence Center in Jefferson County. You have to attend an anger management class as a condition of your probation, and you cannot have any contact with Melissa Elliott, and you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Elliott, Mr. Lamar, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Okay. Mr. Lamar, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Lamar, I will be handing to your attorney for him to give to you an admonishment pursuant to section 176.1 of the Texas Administrative Code, and I will go over this admonishment with you. In accordance with the Texas Administrative Code, section 176.1, the court hereby admonishes you of the following. Number one, you are by entry of order of judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code section 46.013A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Order for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code, Section 46.02, Unlawful carrying weapons. Penal Code, Section 46.04, Unlawful possession of firearm. Penal Code, Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking or trafficking case. Family Code, Section 85.026, warning on protective orders. Now, Mr. Lamar, that the admonishment that I just read and that was just handed out to you, that's your copy, and you can keep that for your records. Mr. Lamar, stand on the X where your attorney is. You're going to follow the instructions of our court clerk. And once you follow those, finish following those directions, you'll be free to go. And you have a blessed day. Thank you.
All right, I need your right thumbprint on that blue light.
Sir, on Zoom on the it says iPhone, what's your name?
Caden Hayes. It won't let me change it.
Caden Hayes. Okay. All right, just put it back on mute. We'll notice that you're here.
Is that him?
Okay.